Hello, this is Matt on the Moon Lambo channel, and I really don't think this is going to go over well. The SEC just filed a 12-page legal brief telling Judge Torres, who will be the judge that makes the final determination on the entire outcome of this court case when it comes to summary judgment, the true finality of this. Well, SEC just told Judge Torres in a 12-page brief that Judge Knepern, who has been helping with pretrial rulings, including discovery, just told her that Judge Knepern is legally wrong and proceeded to just make the same BS cases that we've been talking about for most of this year at this point. Now, this is likely the final update on this particular topic, with the topic specifically being the SEC's bogus allegations that Judge Knepern made an error legally, from a legal perspective, made a legal error in determining that there is not DPP, so deliver process privilege for the SEC. There could be no legal claims there because the SEC, as you know, claims that all of these Hinman, Ethereum free pass speeches, these are legally protected, right? It's supposed to be anyway from their perspective. Judge Knepern says no. And also there's the bogus attorney-client privilege claim that they'd made that Judge Knepern also gave him a big fat no on. So this will be the final update on this topic until we hear from Judge Torres with the final determination, unless Ripple requests an additional opportunity to respond, and they would have to then be approved by Judge Torres. But outside of that, this is the final update on this. So I did go ahead and print up this bitch. I read the thing in its entirety, and I highlighted the most interesting points and made some notes along the way. I'll tell you this, though. Most of it was such a rehash that I only highlighted the parts that I found either new or stupid, which means most interesting. And other than that, all I'm going to do is share with you opinions from a couple attorneys, including Attorney John Deaton. So this one may be a legal video that I'm covering that might be shorter, dare I say, than many of the others. Because typically when I'm covering one of these things, it's like 20, 30 minutes, So we'll see if we can get out of here a little bit faster than that. But I didn't want to bore you with the same crap over and over again. There's only a small bit of overlap and table setting necessary for stuff like this. But I will say this, the SEC made some ridiculous assertions here. There is some new ridiculousness. But before going further ado, and be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. First, I want to give a shout out and credit to James K. Filan, who is an attorney within the XRP community who shared this legal brief. Also wanted to give a shout out to Attorney John Deaton's crypto law organization, which shared this legal brief with the community as well. And Attorney James Filan here wrote the following. The SEC has filed its reply brief in further support of its objection to Magistrate Judge Knepern's orders compelling the SEC to produce the Hinman speech materials. Now, folks, and I've mentioned this before, but it's worth repeating, in particular in a situation like this. Judge Knepern and Judge Torres, I'm not going to say that they're best friends. I have no idea. I don't know. Maybe they go get ice cream together on the weekend, but I can tell you this. They work together, and they do communicate on this case. So it would be kind of wild to me if something this big, made it this far, and there was no communication between Judge Torres and Judge Knepern. And if there was communication, then it would be even more surprising if it made it this far, if Judge Torres didn't point out, okay, but the SEC, they're going to come back and complain, and then my opinion's different than yours, Judge Knepern, so I'm going to have to rule against you if that happens. Don't you think something like that might have been said at some point over the last 8 months? See, that's why this is so freaking stupid. Well, it's one of many reasons. It's like 11 billion reasons why this is absolutely stupid. So here's what Attorney John Deaton had to say. There are actually a couple tweets from him. He wrote, in my reply letter to Judge Torres, I wrote, quote, that speech, of course referencing the Hinman speech on Ethereum, that speech has been the main focus of litigation throughout this case, and it continues to dominate the proceedings, end quote. 1 year ago, Judge Knepern ruled the documents must be turned over. Yeah, there's nothing to see. And so you know what he's getting at here is saying, yeah, nothing to see here. There's nothing. I mean, think about it. There's nothing. Except for, why the hell would you fight this hard for this long on this one topic when you don't behave quite like this on anything else. You've never fought so hard, SEC asshats, to prevent anything from getting out. It's at a point where it looks severely desperate, and all we can do is speculate as to what it is that you're trying to hide, the skeletons in the closet. And then there was this separate tweet, and community member JV shared a footnote, and I'm going to get into all of the specifics a little bit later in the video, but there was a key part that I will mention even right now. He highlighted in this footnote that the SEC wrote, here we go, in regards to Ripple holding so much XRP. Yeah, so it was on the topic of Ripple having a lot of XRP, specifically a ton of it in escrow. And there's a quote from the SEC which reads in this footnote as follows: Ripple owns the majority of the XRP supply. Its actions may affect the success of the cryptocurrency. It may have a hard time meeting the SEC's decentralization bar. End quote. And we'll just note here that that quote from the SEC came from an article on June 15th, which was the day after the Ethereum free pass speech. So somebody was sharing an opinion there that Ripple's escrowed XRP could be an issue. And I'll share my thoughts on that a little bit later in the video, but I wanted to share with you what Attorney John Deaton had to say about this, because this is interesting. Because again, that article, one day after the Ethereum free pass speech, is from Fortune.com. And Attorney John Deaton noted the following. He said, "Of course, it's a double-edged sword for the SEC to cite or rely on such comments, considering 7 months later, Coinbase met with the SEC and informed the SEC that Coinbase didn't consider XRP a security and intended to list it, and did in fact list it in February 2019. So think about this, folks. June 2015, the SEC is now relying on this statement of public knowledge. The public. Obviously, this is the headline from one day after. Public knew, right, that there was concern that XRP might be viewed as a security by the SEC. That's what the article asserts right there. The SEC is relying on that. Okay, well then if it's so obvious, why then, 7 months later, when Coinbase officials were sitting in your office arguing why XRP is not a security, why didn't you say anything then? Why didn't you bring up this Fortune.com article like, well, whoa, wait a minute, did you even read this? Right? Because this is important. They're citing it in the case right now. Why didn't they do that? See, this doesn't look good for them. Nothing is going well for the SEC, let's say. Nothing's going quite swimmingly, if you know what I'm saying here. So let me go now into the bits that I found the most tasty in terms of morsels here. And we'll go straight on down. For those that you want to look at, is on your screen here. And we'll start on this page right here. And I'll highlight the first word where I start reading here. So check this out. This is what the SEC wrote. I'm going to go through that paragraph, and then I'm going to share with you my thoughts on this. Check this out. So SEC writes the following. Defendants incorrectly assert that the SEC effectively concedes that Judge Nepern got the law right. In fact, as the SEC explained in the objections, the orders did not get the law right. So I'll just pause and note, this is the SEC telling Judge Torres that Judge Nepern's doing a very bad job. I just don't think this is going to go well. I really don't. Anyway, their nonsense continues. To the contrary, the order's central holding that because the speech reflected Director Hinman's personal views, the speech drafts cannot be privileged, is premised on legal and factual errors. That holding is based on two false dichotomies that defendants continue to champion. And number one, agency communications can only reflect either personal views or agency views. And number two, the deliberative process privilege, or DPP for short, and attorney-client privilege protect only deliberations about specific agency decisions and not deliberations that reflect personal views of agency staff. But as the SEC has explained, number one, agency communications like the speech may reflect personal views and agency staff's views without reflecting agency positions. And number two, in any event, the DPP protects the personal views of agency staff deliberating over the agency's policy. End quote. Okay, so I will say this. If that sounded terribly convoluted to you and hard to follow, that's because it is. It's nonsense. It's logically incoherent. So look, check this out. As the SEC, an SEC employee can share the same view as the SEC on any topic, okay? We'll agree on that, right? I think that's reasonable. But that's not the issue. The issue is that the SEC argued to the court that the Hinman speech isn't relevant to the market's understanding but that can't be true if it's the official position of Corporation Finance Division at the SEC, for example. So you see how backwards this is? And that's what led to my favorite thing from Judge Netburn ever. And I've highlighted this a number of times before, but it's worth it again because this is exactly what's being discussed right here. Judge Netburn, in just slapping down the SEC in the recent ruling where she said, no, there's no attorney-client privilege here, son. She said the following, and this is the quote. The hypocrisy in arguing to the court, on the one hand, that the SEC speech is not relevant to the market's understanding of how or whether the SEC will regulate cryptocurrency, and on the other hand, that Hinman sought and obtained legal advice from SEC counsel in drafting a speech, suggests that the SEC is adopting its litigation positions to further its desired goal and not out of faithful allegiance to the law. That is my favorite thing in this. All the pretrial stuff to this point, that is my very favorite thing I've ever freaking read. I love it. I need to have that, like, I don't know, bronzed and put on my mantle or something. And then we'll go to the next page here. Bottom of page 2. Yeah, here we go. Okay. So there's this little tidbit here. This part right here. If it would highlight, come on, computer, highlight. I'm clearly clicking. I'm clearly doing this. All right, close enough. There we go. All right. So it reads as follows. This is completely absurd. A careful review of the record shows that the SEC has never departed from its contention that the speech did not reflect the agency's position, but did reflect Director Hinman's personal views as the Director of Corporation Finance and, consequently, the views on the division he led. They're literally stating this with a straight face. It's just lies. The SEC never made this assertion until after Judge Netburn ruled that the Hinman speech emails must be handed over in January of this year. It's a bold-faced lie. Yet here they write that the SEC has never departed from its contention that the Ethereum Free Pass speech did not reflect the agency's position, but did reflect Director Hinman's personal views as Director of Corporation Finance. Did they not change anything? They changed nothing there. And so upon reading that, I had the same reaction as attorney Fred Rispoli, member of the XRP community. He highlighted that same passage and shared it on Twitter, and he wrote the following. Haven't seen anyone clip this part yet, if you did, nice job, but I stopped reading at page 2 after I read the below. That's an eye roll from Judge Torres' faux show when she reads this. I'm telling you. The SEC ass hatter, like, it does not stop. They're literally just fabricating stuff and making up lies. I mean, I laugh because it's absurd. Like, it's disgusting this is happening, but what can you do but laugh? Like, really seriously, what else can you do? I mean, other than, like, I'm obviously making videos tearing it apart so that the public knows, but, you know, at least I'm sharing my opinion. You all can come to your own conclusion, but I think this is complete and utter nonsense. I have a feeling that the vast majority, which is to say about 99.999% repeating of you, agree with this. But if you go to the next page here, towards the top, yes, here we go. Here's another fun one. Let me tell you that. I think it goes down to here. Okay. It reads as follows. First, as to the aiding and abetting claims, defendants assert that the speech drafts are relevant to the individual defendant's scienter. And I'll just pause to note that just means that, you know, it's referencing the knowing of wrongdoing. Like, do you actually understand that? So that's what they mean by scienter. And then the SEC continues. They argue that the speech drafts may reveal that the SEC was unsure about how to communicate information to market participants, distinguishing digital assets that are not securities from those that are. This purported uncertainty on the part of the SEC, defendants claim, means the individual defendants did not know or recklessly disregard that Ripple was engaged in the offer or sale of a security. So, look, here's the thing, though. Hinman emails could prove the only reasonable position Ripple could reach was one of uncertainty due to the lack of regulatory clarity from the SEC. And so, if that's the only logical position Ripple could have achieved, then if internal SEC emails corroborate that, if they display this uncertainty, that is very damning evidence. But here they say What the SEC was thinking and deliberating about internally has nothing to do with that. No, it would be a damning indication that you jerks at the SEC knew exactly how there was not sufficient regulatory clarity. That's exactly what that would mean. And I don't know how the judge could fall for that. It just would not make sense to me. And that's why this grinds my gears, son. We get down to the bottom of page 4, and this is where we get into the fun with the footnote. Oh, party, don't stop, can't stop, won't stop, son. Oh, I love this part. I absolutely love this part. Check this out. So here's a footnote. Starts right here, and then it goes on to the footnote at the bottom of the next page. Defendants assert, without citation, that many took the speech, so again, the Ethereum free pass speech, many took the speech to suggest that XRP was also not a security. To the contrary, market participants interpreted the speech as indicative that XRP offers and sales were securities. And then you can see it picks up down here. For example, a June 15th, 2018 article in Fortune.com titled, "The SEC's Big Cryptocurrency Speech, 5 Things to Know," noted, quote, "Some are skeptical that Hinman's words are good news for Ripple," end quote, "because," quote, "the fact Ripple owns the majority of the XRP supply and that its actions may affect the success of the cryptocurrency mean it could have a hard time meeting the SEC's decentralization bar," end quote, which, quote, "likely means exchanges like Coinbase will stay skittish about adding XRP for now." So there you go. The article that they cited said Coinbase, probably not going to want to list XRP. But then 7 months later, as Attorney John Deaton pointed out, Coinbase comes in, sits down with the SEC, and like, here's why XRP is not a security. And then they ended up listing it, and the SEC didn't tell them not to. And so here's the additional thing. Like, concentration of supply, so because this is about the escrow, that's what they're citing here. Ripple holds too much. Concentration of supply is not the same thing as centralization of control over the network. And also the SEC has never alleged that the quantity of XRP held makes it a security. Never. How much XRP is too much before it's legally a security? Well, it's not even a factor. That's not even a factor in Howey. You see how bogus this is? And they're citing this crap as evident. Like, okay. You do what you want, man. You do what you want. And then I got just one final piece, because most of this is just like a repeat of a lot of the arguments that have already been highlighting recently, but I did enjoy this one. It's on page 7, a little bit of the way through. Yeah, it starts right here. It's just like, I think it's one sentence. Yeah, here we go. Why will this thing not highlight? There we go. If anything, defendants advance... let me try that again. My cadence was off. If anything, defendants advance inconsistent arguments. I'm Failtown right now. If anything, defendants advance inconsistent arguments that the SEC is official. The speech is. I swear to God. You ever have one of those days? Let me try that one more time. If anything, defendants advance inconsistent arguments that the speech is official SEC views for purposes of relevance, but merely Citizen Hinman's personal views for the purposes of DPP. Now, isn't this rich? They're saying that Ripple's arguments are inconsistent because they argued one thing and then they argued another. Is that true, though? Well, Ripple initially argued that Hinman's speech, the Ethereum Free Pass speech, was an official SEC position. They did argue that. But Judge Netburn ruled that it's not an official SEC position. She instead stated that it's Hinman's personal opinion. And Ripple accepted that. There's nothing inconsistent here. Ripple argued one thing, the judge said that's not true, and then Ripple said, okay, we're going to go with your ruling. That's... It's not like they're still arguing it, which is why this is so rich. The SEC, on the other hand, they're arguing multiple different things simultaneously right now. And then for them to claim that Ripple's doing that? Oh, hell no, son. Don't make no damn sense. That's a fun way to end this video, is that they actually did that. All right, I'll just go ahead and wrap up. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.